every one of you to the 2 days national level virtual FDP on IPR and entrepreneurship development by IoT Academy, Chennai. So, our today's discussion revolves around the complete basics of IPR. Let's quickly get into the IP. What does this mean? Usually, we'll be listening to this particular word. So, it is nothing but the creations of our mind. Everything from the work of art to inventions, computer programs to trademarks, and other commercial signs, says the WIPO, World Intellectual Property Organization. So, what is this WIPO? Global Forum for IP Policy, Intellectual Property Policy, Services, Information, as well as for Cooperation. So, IP, intellectual property, it stands as a, you can call it as a potent catalyst, mainly to foster growth and also to promote sustainable development. So, how does IP help us? It mainly empowers, whether it is individuals or entities. It serves as a vital enabler. IP can generate employment, it can nurture businesses, it can even fuel economic progress, and also it can even enhance our social vitality. I know you all must be wondering how all these. Say, for example, now as an individual, you have your own ideas and creations. Say you just come up with something new. It could be a story or an invention or just a cool design. Now, it's time to protect your work from being copied from others. Say nobody can use your work without your permission. Is it or not? Yes. So there comes the concept of IPR, intellectual property rights. What are these rights? They are nothing but the legal rights and protections which are granted or given to the persons over the creations of their minds. What are these creations of the minds? Just now I told you they are the IP, intellectual property. So these IPRs, they give the creator. You can call him the creator, owner, innovator, inventor. Everything means the same. So this IPR gives us the exclusive right over the use of my creation, your creation for a certain period of time, says the WTO, World Trade Organization. You all must be aware of this. This is the only global or international organization which deals with the rules of trade between the nations, between countries. So it helps the producers of goods, services, exporters, importers, mainly to conduct their business. So with this brief introduction, let us also see what is the history of IPRs. See, this concept of IP, intellectual property, it can be traced back to ancient Greece and Rome, right? Where actually there were laws protecting the works of artists, inventors. Say, for example, we have Athenian law of Draco, which is approximately around 621 BCE, before Common Era. So this law actually prohibited the unauthorized copying of sculptures and paintings. Think of that ancient time. See, so and even during the Middle Ages, IP was actually further developed by guilds and universities. What were these guilds? So they were the associations of merchants, artisans. They had their own rules to mainly protect their trade secrets of especially of their members. And universities such as University of Bologna, they actually granted exclusive rights to their graduates, mainly to teach or even to practice their profession. Then coming to Renaissance period, so it actually saw, you can call it as a renewed interest in the protection of IP. Uh, that was the time which also witnessed the rise of printing. So what was happening? It was possible to easily reproduce the works of authorship, right? So in 1455, Venice was the first city to issue a patent, and actually it granted exclusive rights to the inventor who comes up with a new process. Then what happened? IP actually continued to evolve even during the 17th and 18th centuries. In England, The Statute of Monopolies in 1624, it was passed mainly to limit the granting of monopolies, or you can call it as some kind of privileges. But it also recognized the validity of patents, mainly for the inventions. Then in France, the first copyright law, it was passed in 1777. Coming to 19th and 20th centuries, it actually saw the development of international treaties on IP, intellectual property. The Paris Convention, very, very important for the protection of IP during 1883. It was the first international treaty mainly to deal with the patents, trademarks, industrial designs, and everything. Then, uh, the Berne Convention, it was mainly for the protection of literary and artistic works. It was in 1886. It was the first international treaty mainly to deal with the copyright. Now, in the 21st century, intellectual property, this concept of IP, it has actually become increasingly important. Why? Very, very simple. Because our global economy, it has become more interconnected, isn't it? You all would have come across the agreement on TRIPS, TRIPS, trade related aspects of intellectual property rights. It is actually a WTO treaty, World Trade Organization treaty, and this sets the minimum standards for the protection of IP. It also helps to promote economic development as well as innovation. So, with all these facts, we also have to remember this concept of IP, it has been shaped by a variety of factors. It could be economic, social, or say even political considerations. So, the protection of IP, it has been a source of controversy as well. Why do I say this? Because some people argue that the protection of IP, it stifles innovation. While others also argue that it is necessary to protect the rights of creators, it is necessary to protect the rights of inventors. And the law of IP, it is constantly evolving because we are witnessing new technologies and more creative works are being developed. Right. Okay. So there are several types of IPR, and each of it is designed to protect different forms of creative and innovative work. Let us discuss one by one. So copyright, it's nothing but a legal right which grants the creator, as I told you, creator, inventor, owner, everybody means the same. Whoever is the creator of a original work, he or she will be granted the exclusive right to its usage as well as its distribution. In India, especially the copyright protection is governed by Copyright Act 1957. Okay. So what types of works are protected under the Copyright Act? Would anyone be able to answer? What types of works are protected under this Copyright Act? Audience, you can just unmute yourselves. You can answer, or you can even type in the chat box. I asked you a very question. What types of works can be protected through this Copyright Act? Anybody? I have already mentioned it in the slides. Textbooks, okay. Any innovations? Okay, fine. Thanks for the input. Right. All this, whatever I have mentioned, can be protected under Copyright Act. Literary works. As somebody told me, textbooks or any kind of books, articles, computer programs, all this will come under this literary works. Say, for example, we have Harry Potter and the Sorcerer's Stone, which is by the famous author J.K. Rowling. So, the text of this book, it is protected by copyright. What does that mean? Means The copyright is preventing others from reproducing it without the permission of the author, right? Or without the permission of the copyright holder. Then coming to artistic works. So what are artistic works? It could be the paintings, drawings, or even photographs. Say, for example, Mona Lisa, the famous artwork, right, which is done by Leonardo da Vinci. It is protected by copyright. Then, coming to dramatic works, the plays, scripts, choreography, all this will fall into the category of dramatic works. Say, for example, we have Romeo and Juliet by William Shakespeare. It is protected by copyright because they are trying to guard themselves against the unauthorized performances or unauthorized adaptations, right? Then, musical works, compositions with or without lyrics. Say, for example, you all would have listened to this song Jai Ho, right, which is a song from the movie Slumdog Millionaire. So, this song won the Academy Award for the Best Original Song way back in 2009. So the musical work, it includes the arrangement, melody, lyrics of the song, and it is protected by copyright. What does it mean? It means that they are trying to ensure that A.R. Rahman, he has the control over its usage as well as its reproduction. Right? Okay. Then cinematographic films. In simple words, it could be the audio and visual works. Say, for example, the film Titanic, which is directed by James Cameron, it is a cinematographic film which is protected by copyright. So this copyright, actually it covers various elements. It could be the screenplay, visual components, audio components, or say even the overall presentation of the movie. Any kind of unauthorized reproduction, distribution, or public performance without the permission, it will infringe on the copyright of the movie as well as its creators. Then, sound recordings. They are nothing but the recorded sounds. Say, for example, we have Thriller by Michael Jackson. So, it comes under this sound recordings. Okay. Yes, and the duration of this copyright protection, it actually varies depending on the type of work. Say, for example, we have this literary, dramatic, musical, artistic works. The duration of the copyright protection is lifetime of the author plus 60 years. Similarly, for this cinematograph films or sound recordings, whatever we discussed, it is actually 60 years from the date of publication. The creator is usually the first owner of the copyright. But actually, as I told you in the first slide, in certain cases, it may be owned by the employer or some other commissioned party also. Then coming to the Copyright Office in India, it is a part of our Ministry of Education and it is responsible for copyright registration. There are also offices in New Delhi, Mumbai. We also have one in Chennai, Kolkata. What do you have to do? You have to just fill out the appropriate application form based on the type of your work. Say, for example, we have form number 14. It is mainly for your literary, dramatic, musical, and artistic works. If your work falls under this category, definitely you can fill that proper appropriate application. You can attach the supporting documents and you can submit your application either online or a physical copy to the Copyright Office. Then you will be supposed to pay the requisite fee for this copyright registration, and then the Copyright Office, they will process the application. If at all any kind of say additional information is needed, they'll definitely get back to you. And after the examination, any discrepancies, they will definitely be addressed. Once it is approved, then the Copyright Office will issue you a registration certificate. So as a copyright holder, you can reproduce your work, you can communicate it to the public, you can adapt or even you can translate the work, and even you can distribute the copies. Coming to India, India is a party to the international copyright treaties, as I told you about the Berne Convention. So this provides the global protection for the creators. if at all, say there is any kind of infringement, like there is unauthorized reproduction or distribution or any kind of public display of a copyrighted work by others apart from you, or any kind of violation of your exclusive rights which is granted to you as a creator or a owner of your own IP, then court will also provide some kind of remedies. Suppose for a copyright infringement, they might uh, give you injunctions, means they'll ask the third party to just stop restricting a person or entity from producing your property, right? Mainly injunction is provided to prevent the any kind of further infringement, or they might even ask them to pay damages or um, an account of profits. That means the inventor will be paid for the harm caused by the unauthorized person, or there might even be the seizure or destruction of these any kind of unauthorized copies. You can even call it as infringing copies. Hope we are clear so far. Are there any doubts till now? Are we clear so far? Okay, fine. Thank you. Okay. So what is this trademark? Can anybody answer? What are trademarks? You can just unmute yourselves, or even you can type it in the chat box. What are trademarks? Looking at these images, looking at the definition, do you get any idea? Logos, okay. Anything else? Exclusive symbols, right? Okay. Fine. Thank you. So a trademark, it is a distinctive sign which is capable of distinguishing the goods or services from one enterprise from those of other enterprises. Right. See, in India, this trademark protection, it is governed by Trademarks Act 1999. Now, I said distinctive sign which is capable of distinguishing the goods from one company to the other. Now, how do we distinguish this? How do we know whether a car belongs to Toyota or Volkswagen or Ford, or whether this car belongs to Honda, BMW, so on, Volvo, GM? How do we know? Or say a face powder, is this from Maybelline or L'Oreal Paris or Revlon, MAC Cosmetics? How do we know? Through this symbols, right? Or through this unique signs, we are able to distinguish it. We also have a few types of trademarks. First, we have word marks. It is a text or a combination of words. As you see in the example in the image, we have FedEx. We also have Google. It is exclusively the text or the combination of words. Then coming to the logo marks. As somebody has already mentioned in the chat box, yes, logo marks are also the one type of trademarks. Brand, it is represented by a distinct graphic or any kind of symbol, but there will be no any kind of accompanying text. We have the famous Apple logo. It is a bitten apple. As soon as we see that, we all know any kind of equipment, either our phone or laptop, anything, it belongs to the Apple company. Whether it is an iPad, whether it is an iPod, we will understand, isn't it? That is the power of logo. Then coming to combination marks. A combination of both text and a symbol or any kind of graphic. So we have the golden arches which are accompanied by the text McDonald's, and this is a very famous mark for our combination marks. Service marks. It tells us it is specifically for services rather than goods. We have, what does this symbol say? N, Netflix, right? It is a streaming service and it is obvious. It actually provides on-demand movies, TV shows, and many more original content. There is no any kind of tangible product here. So they are the service marks. Now, how can you go ahead with the registration process for trademarks? First of all, you have to conduct a thorough search to ensure whether the logo or the symbol or the graphic, whatever I have, it is unique, right? This step is called trademark search. Then you can submit your trademark application to the trademark registry. Then the trademark office, they will examine the application, whether there is compliance with the requirements or not. If it is accepted, yes, your trademark is published in the trademarks journal. In between, before you get the registration, during a specific period of time, a third party can come and oppose in between. So they might say, already we have this mark, already we have this particular logo, these kind of words or these kind of combination of letters or these colors, everything, it is registered by us, it belongs to our company. So if at all somebody opposes this, so you will not be granted a trademark. If there is no opposition, yes, your trademark will be registered and a certificate will also be issued. And the trademarks, they are initially registered for a period of 10 years and it can actually be renewed indefinitely in the subsequent periods. As a trademark holder, what is your exclusive right? You can use your trademark for for your designated goods or services. If at all there is any kind of, say, unauthorized usage, definitely you are welcome. You can take a legal action against that person. See, when does this kind of TM infringement, trademark infringement occurs? When someone uses a similar mark for the similar goods or services, whatever you are using. That is called the trademark infringement. The remedies, it actually includes the damages or injunctions, as we discussed in the copyrights, or there might also be the destruction of those kinds of infringing goods. Say, for example, we have Pepsodent by Unilever. They have a smile-like symbol, isn't it? It is their trademark. For example, the same thing it is used by Oral-B or Close-Up, who all are trying to use the same kind of graphic design elements. What will happen? Right? One company has to take, the first ever company who has registered, it has to take the legal action against the unauthorized usage of other companies, isn't it? Yes. And our country, India, it is a member of international agreements. So like Madrid Protocol, mainly this facilitates the international registration of trademarks, right? Then coming to the collective marks, India also recognizes this collective marks. In simple words, collective marks means it is used by the members of an association. Say, for example, we have Darjeeling tea, right? It is very, very famous. So the logo of the Darjeeling tea, you can see in the image, it is used by all the Darjeeling tea producers. What does it mean?
Sorry to interrupt, ma'am.
Yes, ma'am.
Ma'am, your slide is not visible, ma'am.
Okay, ma'am, just a minute.
Yeah.
Is it visible now, ma'am?
No, ma'am.
Not yet. Okay. Or, ma'am, can you share it from your end?
Yes, ma'am. Sure, I'll do it, ma'am.
Yes, ma'am. Slide number 6, trademarks, ma'am. Yes, ma'am. Okay. Can we just continue? Okay. Yeah, I was just speaking about this collective marks. So there is an example of the logo which is used by the Darjeeling tea producers. What does it mean if they are using this particular logo? It shows that the tea, it is from Darjeeling, and it actually meets the quality standards which are set by the Darjeeling Tea Association, right? Then coming to the certification marks. So it indicates the origin or the material or the mode of manufacture. Say we have a handloom mark here. What does it show? It is a special mark on the textiles, as we all know. It shows that the textiles were made using the traditional handloom methods. And it also certifies that the product's authenticity, also the product meets the quality standards, right? Okay. Ma'am, next slide. So a patent, it is nothing but an exclusive right which is granted to an inventor mainly for a new or an inventive product or even a process, right? It provides the inventor with the right to exclude others. Others cannot make, use, sell, or import the patented invention if it belongs to me. Say in India, we have three main types of patents: product, or you can call it as utility patents. It covers, in simple words, new and inventive products, as the name tells you, product patents. Say, for example, a pharmaceutical company in India, if it invents a powerful new medicine, mainly to treat some kind of common illness, now they get a product patent mainly to safeguard their formula, and they are also making sure that nobody else is trying to copy their formula. Then we also have process patents. As the name tells you, it is protecting the new and inventive methods or processes. So, for example, an Indian company, it figures out a smart way to extract some kind of essential oils from plants. Now they apply for process patent. For this inventive method or a novel method, they are applying for a process patent. Then we have design patents. It is nothing but guarding the ornamental design of an article. Let us say a designer, especially in India, they create a distinctive or aesthetically pleasing casing for a smartphone. Okay. So to protect the unique or visual elements of this design, they are trying to apply for a design patent. Okay. It's nothing but the ornamental design of an article. Then we have plant patents. So these patents are granted for new and distinct varieties of asexually reproduced plants. What do we mean by this? That means plants are cultivated through methods like budding or grafting, right? How do we usually cultivate the plants? Mainly through seeds. But these plants are cultivated through the different methods. You all would have come across this, the peace rose, PEACE. It is a specific variety of rose, and this has been granted a plant patent. So the patent system in India, it is administered by the Indian Patent Office, and this operates under the CGPDTM, Controller General of Patents, Designs and Trademarks. Say whatever I feel as an invention, can a patent be granted to that? No. Especially in India, to be granted a patent, it must be your invention, it must be novel, and it is not anticipated by prior publication. Somebody cannot say we already know this, right? Yes. And it must also involve some kind of inventive step, right? And it must not be obvious. to somebody in specialized in that particular field. They cannot say, yes, after this, only this comes. After one, two comes. After two, three comes. We all know this. So it must not be obvious. And patents must be capable of industrial application. That means they can be utilized within the industrial settings or processes. Can anybody tell me what is the term or a duration of a patent in India? For how many years a patent is granted in India? Any guesses? What is the duration of patents in India? Term of patents? It's okay, you can type it in the chat box. Okay, 10 to 20 years. Okay. Any other guesses? Trademark is 10 years, so maybe longer. Okay. Good guess. Yes. The term of patent in India is 20 years from the filing date of your application. Okay. So how do we file for a patent? It's simple. First, you conduct a thorough search, okay, to ensure there is some kind of novelty of my invention. That is called patent searching. Then what we will do? We will do a patent drafting. That means we just prepare a detailed patent application. Then we submit the application to the Indian Patent Office. They will examine the application whether there is compliance with the patentability criteria is there or not. If our application meets all the requirements, then the patent is granted. Now, the patent holder, he or she has the exclusive rights to make, sell, or even import the patented invention. Even we can authorize others to use our invention, mainly through licensing. So, our nation, India, is a signatory to international treaties, especially like the one already we discussed, TRIPS, trade related aspects of intellectual property rights. So this actually harmonizes patent protection globally. Okay. Just now we discussed some examples that coming up with a formula of a revolutionary medicine. Imagine someone in India copies our formula, right? That whatever we have come up with, mainly to fight with the common illness, and somebody is using our formula without permission. So that is called patent infringement. Or I already also I mentioned that one of our rivals, they start using the exact method whatever we used to extract those essential oils, and this has been patented by our company. That is also infringement. Or say we also discussed about our stylish phone casing, right? Even if someone copies that unique design of our smartphone casing, that also comes under the infringement. If this kind of infringement happens, there are again remedies. Cease and desist. Actually, the patent owner, he or she can demand whoever is copying that copycat just to stop it right away, right? Because this belongs to me. It is patented by me or my company. Then the infringer, whoever has accessed, he or she might have to pay for the damages which is caused by their act of copying. Then the court can order the infringer to halt the production, to stop the production, or to right away stop the sale of that copied product. Even legal action can also be taken. The patent owner can take the infringer to the court mainly to enforce their rights. Ma'am, next slide. Trade secrets in India. Trade secrets are nothing but the confidential business information, right? And this information, it provides a competitive advantage to a company. See, unlike these patents or trademarks, whatever we discussed, trade secrets, they are not registered, but they are protected through the maintenance of confidentiality. That is very, very important in trade secrets. That means See, trade secrets, they are protected as long as they remain secret and as long as they provide a competitive advantage for me to survive in this market. And there is no fixed duration for this, and the protection is contingent. That means it is dependent on maintaining the confidentiality. If you maintain confidentiality, secrecy about your business, till that time your trade secrets are protected, in simple words. Okay. The examples of trade secrets could be your famous Coca-Cola formula, right? Do we know how do they prepare Coca-Cola? Yes, we have so many competitors to them, many drinks next to it, but do we get the same taste? Do we know what is the trade secret of Coca-Cola? No, till date. So they have maintained the confidentiality. Or any kind of proprietary manufacturing or production processes, what a particular company is doing, how is it they are doing their manufacturing processes, we do not know, right? Usually they'll not let it out. Or even the confidential databases of your customers or clients, the customer lists, whatever the businesses have, that also comes under this trade secrets. Then even your business plans, right? Which are like strategically valuable plans, proposals, and which has an outline of our company's vision or what are our goals, methods, right? All these things are contributing to the competitive edge in the market. So all of them, they fall under the trade secrets. As I told you, India does not have a specific statute which are governing the trade secrets. And protection, and what about the protection? It is primarily derived from the common law principles, whatever we have, or the contractual agreements, and also the IT rules 2011, information technology rules, which speaks about the reasonable security practices, procedures, and even the sensitive personal data or information. Right. What are the secrecy measures? Now, how to maintain secrecy? Yeah, we have a few ways. NDAs, executing the non-disclosure agreements with our employees, with our partners, or even with the third parties. Right? With these agreements, we are asking them to maintain the confidentiality, secrecy. Then we are also trying to limit the access to this kind of confidential information. How? Maybe on a need to know basis. If somebody comes and asks me, what is the formula of this? What is the formula of a oil you have been producing or the shampoo from your company? First, I'll ask them, what is the need to know? Who are you to my company? Right? Through this, I'm not letting everybody know the confidential information, and also I'm trying to limit the access to each and everyone. Right? Whoever has the right, whoever has the need, only knowing about this. Okay. Then we also have to train or educate our employees. What is the importance? Why do we have to maintain the confidentiality? If they don't maintain any kind of secrecy, what will happen? Right? Okay. Then violation of the confidentiality agreements, it can lead to legal action, including any kind of damages or injunctions. So, as stated before, India is a member of TRIPS, trade-related aspects of IPR, and India also follows the international best practices for the trade secret protection. There are also a couple of challenges in maintaining this trade secret. Employee mobility. We often see there is a movement of employees who has the access to our trade secrets. They might change the company. They might suddenly resign. So they know everything in and out of our company, what is happening inside my company, whether it is a formula, whether it is a recipe, whether it is a manufacturing process, anything. So they have the access to my trade secrets. Tomorrow, if they reveal it to somebody, how do I stop them? Not possible, right? Then also protecting the trade secrets in a global business environment is really very, very difficult. Ma'am, next slide. Industrial designs. Industrial designs are nothing but the aesthetic aspects of an article. It could be its shape, configuration, ornamentation, or the composition of colors, whatever we use. And all these are giving a unique visual appearance to that particular product. So industrial designs, they are primarily aimed at protecting the visual design elements of the functional items. So for example, in consumer products, we have electronic gadgets, we have furniture or the kitchen appliances. Under packaging, we see the unique bottle shapes or any kind of packaging designs. Similarly, for automobiles, we have the car exteriors, interiors, all this will fall under the industrial designs. In case of textiles, we have unique fabric patterns, right? Okay. So industrial designs in India, they are protected through the registration with the design wing of our same CGPD TM, Controller General of Patents, Designs and Trademarks. The protection duration, any guesses for this industrial designs? What will be the protection duration of this? What is the protection term for the industrial designs? Anybody wants to answer? What will be the term of protection of ID industrial designs? Okay, no problem. The duration initially it is for 10 years and it is extendable for another 5 years, totaling 15 years. So what will be the eligibility criteria? Are all the designs, whatever we just try to go and uh, put it in front of a registration office and we'll ask them to grant us industrial design? Is this possible? No. Novelty is the first criteria. The year design must be new or original. As we discussed in the patents, there must be non-obviousness. The design should not be obvious to a person, whoever is skilled in that art. Then the design should also have the visual appeal or a aesthetic appeal. Then if our industrial design has all these factors, then our registration process also becomes very simple. You can submit an application with the designs office. They will examine the application for the compliance with all their eligibility criteria. If accepted, the design is published in the designs journal. And in the meanwhile, if the third parties are not opposing the registration, if they don't claim that yes, this design belongs to me, if there is no opposition, your design gets registered. Right? Now, as the design holder, you also have exclusive rights to make, sell, use, and import your article with that registered design. Infringement definitely will occur when someone uses your design without any kind of authorization. So as design holder, you can take legal action for any kind of damages or injunctions, right? And it's a member of Hague Agreement, HAGUE, and it facilitates international registration of industrial designs. Ma'am, next slide. Okay. Geographical indications, GIs. Could someone provide an answer? What are GIs? Have you come across this? Geographical indications? What are GIs? Looking at the image, are you getting any idea? What are GIs? What are geographical indications? Place of innovation. Okay. Thanks for that. Yes, partially correct. So GI, geographical indications, it is a sign used on products that have specific geographical origin. Not only that, it also possesses the qualities, reputation, or characteristics that are essentially attributable to that particular place of origin. Geographical indications, it can be registered either for agricultural, natural, or even for the manufactured goods. Say, for example, we already discussed about the Darjeeling tea, isn't it? It is known for its unique flavor, aroma, and it is grown in the Darjeeling district of West Bengal. Similarly, we have a fragrant rice variety which is grown in the specific regions of India and Pakistan. That is our basmati rice. This is how they get the name. And we have Alfonso mango, which is grown in certain regions of Maharashtra, and it is also known for its distinct taste and aroma. As I told you, it is they have a specific geographical origin, and they also possess a certain qualities or characteristics which we can attribute to that particular place of their origin. Geographical Indications Registry, it is the authority which is responsible for administering the registrations of GI in India. It again operates under the Office of Controller General of Patents, Designs and Trademarks. Now the application, it can be filed along with the, you can just give the details of your product, its characteristics if you want to register for the GI, and the geographical area of production, and you also have to provide the evidence. What is the link between this particular product and the geographical origin? Okay. Then once registered, ERGIs, geographical indications, they are protected for an initial period of 10 years, and it can definitely be renewed indefinitely. Okay. So Geographical Indication of Goods Registration and Protection Act 1999, it is the primary legislation which is governing geographical indications in India. And this act actually came into force on September 15th, 2003. You must be wondering, what are the benefits if I go for a GI registration, geographical indications registration? First and foremost, it prevents the unauthorized usage of geographical indication by others. It also enhances the market value, economic value of the products, right? When you try to associate specific geographical origin. And it also mainly helps in preserving the traditional methods of production. Thereby, it is also promoting the cultural heritage. Okay. Unauthorized usage is very, very common of a registered GI. It is prohibited and penalties are prescribed for infringement. It could include fines, injunctions mainly to cease that infringing activity, and in some cases, imprisonment for individuals who are involved in severe violations. And all these things are based on the legal framework of that particular country, right? So the TRIPS agreement, it recognizes the importance of protecting the GIs at the international level. Ma'am, next slide. Plant Variety Protection, PVP, in India. It is a form of IP, and it provides exclusive rights to the breeder for a new and distinct plant variety, as the name tells you, right? It actually ensures control over its propagation or any kind of commercial exploitation. In India, we have Protection of Plant Varieties and Farmers' Rights, PPV and FR Act 2001, and this governs plant variety protection. Okay. Now, what is the eligibility criteria? Can all the plant varieties be registered? No. So the plant variety should be new, or it is not widely known to everybody. The first eligibility criteria is novelty. Then it should be distinguishable from the existing varieties of plants. Already some plant is there. So now I cannot go on as for this plant variety protection. And the characteristics of that particular plant variety should be uniform for each plant. And these characteristics, it should remain stable even after any kind of repeated propagation. So there are also exclusions here. Certain kinds of plants or traits, they may be excluded from protection. Some plants, they may be harmful, right? Even to us humans or animals, right? Or even to plant health. We call it as detrimental. Or some plants, they may be causing some kind of environmental damage. So those plants are excluded from any kind of protection under this particular act. If you want to go and register this, you can submit an application to the Plant Varieties Registry. They will examine the application for compliance, this is meeting all the eligibility criteria or not. If it is accepted, this particular variety, it is published in the Plant Varieties Journal. Even third parties can also oppose the your registration process. If there is no any kind of opposition from anybody, then this particular variety can be registered. Then as a PPP holder, you have the exclusive rights. You can produce, you can sell, you can market, you can distribute, import, export this particular protected variety. The protection period for the plant varieties also varies. Any guesses from the audience? What will be the protection period for the plant varieties? What will be the duration? What will be the protection period for the plant varieties? Any guesses? Okay, no problem. As I told you, this protection period also it varies between the plant varieties. If they are the field crops, it is from 15 years from the date of registration. If they are any kind of trees or vines, it is 18 years from the date of registration will be the protection period. We were actually discussing about this PPV and FR Act. This also recognizes and protects the right of farmers, right, who have actually traditionally cultivated and also saved the seeds of this protected variety. So this PPV and FR Act recognizes and protects the rights of those farmers also. And definitely infringement occurs when someone reproduces or sells or exports this particular protected variety without authorization. And the legal remedies can include damages or even injunctions. Ma'am, next slide. Okay. Integrated circuit IC layout design, or even you can call it as semiconductor layout design. It is nothing but, in simple words, the 3D, three-dimensional arrangement of electronic circuits on a semiconductor product. So in simpler terms, it is nothing but a design or a blueprint of the tiny circuits whatever we have on our electronic devices. So India protects these designs under the Semiconductor Integrated Circuits Layout Design Act 2000. This law is something like a bodyguard for the creative layout designs which are used in your electronic circuits. For protection, to be eligible under the protection, a layout design, it must be original, right? It means it's not just a copy of something already out there, right? And it also should be commercially used in India. And for the registration process, you can submit the design to the Semiconductor Integrated Circuits Layout Design Registry. Okay, then they will check if it meets the originality or not, or if it is meeting the commercial usage criteria or not. Okay. If this stage is passed, then the design gets registered and the owner also will get a certificate. Then the owner of the registered layout design, he or she has the exclusive right. They can decide who can make, who can sell, or who can use my ICs with that particular design, integrated circuits. Right? It is something like having the only recipe for a special dish. And only you have it. Okay. So this protection lasts for 10 years from the date of filing the application, or even from the first time usage, right? From commercial usage, whether it is from the date of filing the application form or from the first time it is commercially used, whichever comes first, the protection lasts from that particular date to 10 years. After that, the protection retires. If someone copies the design without permission, as the owner, you can take the legal action. So remedies include stopping the copying, or getting paid for the damages, or even getting the infringing copies destroyed. right? Based on the treaty on the intellectual property in respect of the integrated circuits. And this India, it is a signatory for this, and it is commonly known as Washington Treaty. Okay, this provides the international protection for layout designs. Ma'am, next slide. Okay, utility models or petty patents in India. It is a form of IP protection, and it covers small scale innovations or some kind of improvements that you make on the existing products or processes. That's why we call it as petty patents. It means small, right? So utility models in India, they are governed by the Designs Act 2000. So it includes provisions for the registration of both industrial designs and the utility models. Now, here in this utility models, the emphasis is on the what is the practical utility, or what is the functionality of the invention that you have come up with. Right. Here also again the eligibility criteria includes first and foremost novelty. The utility model must be new, and it is not published elsewhere, or it is not publicly disclosed before the filing date. Please mute yourselves. There's lots of disturbance. Thank you. Yeah, and it should also involve an inventive step where it is showing some kind of improvement, right? Already there is some kind of existing knowledge, and there is a slight improvement on that. You can see the improved bottle cap here. So it is a new and a more efficient design for a bottle cap, and it is ensuring better sealing or a easy opening, right? This bottle cap is already there, existing knowledge is already there. There is an inventive step to improve it. Okay. Or even you can have a, as the image tells you, foldable umbrella with some kind of additional features. Say, for example, you can come up with a built-in flashlight or some kind of wind-resistant mechanism, right? Yes. So those all comes under your utility model. Then coming to the registration process, you can definitely submit an application to the designs office. They will examine your application, whether it has compliance with the eligibility criteria or not. Then if accepted, your utility model, it is published in the designs journal. Okay. Similarly, as we spoke about so many other IPRs, third parties can also oppose the registration. If there is no any kind of opposition, your utility model is registered. Then the registered owner of a utility model, he or she, they have the exclusive right to prevent others. Others cannot make, use, sell, or import your protected innovation. And the protection period for utility models is 10 years from the filing date, and it is non-renewable. Okay. Now, infringement also occurs when someone uses your utility model without authorization. Legal remedies can also include the damages and injunctions. Ma'am, next slide. Okay. So why after looking into so many types of IPRs, why intellectual property is essential for your business? There are several reasons. Establish competitive edges. See, intellectual property such as trademarks or unique product designs, it actually distinguishes your business from your competitors. It safeguards your brand identity, right? Through that, it is making it recognizable and memorable to your customers, isn't it? Then it can also create income streams. How? See, patents, licenses for your innovative products or processes, it can be monetized. You can allow others to make use of your IP in exchange for some fees, right? Thereby, you are trying to create additional revenue streams for your business. It can also minimize tax exposure. See, managing your IP strategically, definitely it will lead to tax benefits. See, some jurisdictions, they offer tax deductions or credits for the expenses which are related to creating, acquiring, or maintaining the IP, intellectual property. It also acts as a source of competitive intelligence. See, by analyzing the IP landscape, or say for example, some patents are filed by your competitors. Now, what is the use if you know about this? It provides you the valuable insights into what are the R&D activities, research and development activities of my competitors. So this intelligence, it helps you stay informed about what are the trends in the industry. What am I doing? What my company is doing? What my competitors, my rivals are doing? And also I can get ideas about the potential areas for innovation. Then ease entry to funding. See, a robust IP portfolio, it enhances your business credibility, especially when you're trying to seek some kind of financing from outsiders. Whether they are lenders or investors, they are like more likely to support your ventures if at all you have some kind of valuable and protected intellectual assets, right? Because with these valuable intellectual assets, it is demonstrating your strong market position as a business. Then drawing investors and collaborators. See, investors and strategic partners, they are attracted to a business with a solid IP foundation. I repeat, any kind of investors, lenders, strategic partners, collaborators, they are attracted mainly to your business if you have a solid intellectual property foundation, right? A unique brand, a patented technology, or exclusive rights to certain innovations. It actually signals long-term sustainability and also the growth potential. Evade and alleviate the pertinent risks. See, registering trademarks and patents, it helps others, okay, it helps prevent others from copying your products, or they are not supposed to use your similar branding. So this proactive approach, it actually mitigates the risk of legal challenges. It could be the infringement lawsuits or just protecting your business interests, right? Ma'am, next slide. Okay. In conclusion, I would like to say, respecting IPR, intellectual property rights, it's not merely a legal obligation, but treat it as a fundamental pillar for what? For fostering innovation, for sustaining economic growth, and also preserving the integrity of the creative or inventive endeavors. It could be by anybody, right? So by acknowledging and upholding the IPR, we are ensuring there is a fair and equitable environment, right? Here, the creators are motivated to push the boundaries. Investors are confident. They are ready to support any kind of groundbreaking ideas, and the society as a whole gets benefited from a rich tapestry of knowledge or any kind of cultural expression. And enforcement, somebody, you might be thinking, is it really necessary? Yes, definitely. Enforcement is crucial to maintain the integrity of IP, right? Because in India, we have a comprehensive set of legal remedies, as what we discussed. It has civil remedies like injunctions, damages, compensation, accounts of profits, or delivery up or destruction. We also have criminal actions like criminal proceedings, raids, seizures, and we also have border measures which prevents the entry of any kind of these counterfeit or pirated goods into a country, right? National border measures. We also have ADR, alternative dispute resolution. It is mainly through the mediation or arbitration. Outside the traditional court proceedings, we try to solve it. Then we have international cooperation through the treaties, and we also have the strategic use of technology. So, which type of remedy amongst all these? It totally depends on the nature and the severity of infringement. And it also, as we already discussed, it also depends on the legal provisions that are available in a particular jurisdiction. Okay, so these measures collectively aim to protect the rights of IP owners and also deter any kind of infringement, breach, or even you can call it as encroachment activities. Okay, if possible, let's all conduct public awareness campaigns, okay, to promote a culture of respect for IP, and let us try to discourage the violations. Okay, now let's open the floor for discussion. Any questions or thoughts from the audience is most welcome.